Whether you are caring for an elderly loved one as a court-appointed conservator or guardian, or as an agent named an advanced medical directive or financial power of attorney, or just helping out without any of these authorities, your primary goal in each instance is to provide your loved one with the best care possible as they age. Often that care involves paying for caregivers in their home, or it may involve paying for that care in an assisted living facility or nursing home. Getting good care for your loved one is important. Paying for it is often the challenge. If your loved one does not have long-term care insurance, and many folks do not, then they may have to seek assistance from the federal government program called Medicaid. Our show tonight continues the discussion on adult long-term care Medicaid in Maryland. In this show, we will look at common misunderstandings, asset transfer restrictions, planning strategies used to qualify for this Medicaid coverage in Maryland, and the application process itself. We are pleased to have returning as our guests two Maryland attorneys who handle long-term care Medicaid planning and applications for Maryland adults. They will serve as our guide as we continue the conversation about this long-term care financing option for all who may be traveling on the Maryland Living Probate train. Our first guest is a partner with the Annapolis law firm of Stavely and Solito Elder Law LLC, where she focuses on Medicaid asset protection, long-term care planning, powers of attorney, health care decisions, guardianships, and financial exploitation. She's a certified elder law attorney as certified by the National Elder Law Foundation and is the vice president of the Maryland, D.C. chapter of NALA. She also serves on the Maryland State Advisory Commission on Quality of Care at End of Life and the Elder Law and Disability Rights Section Council for the Maryland State Bar Association. And she also frequently testifies before the Maryland Legislature on Medicaid and elder law issues. Also with us today is the founder of the Farr Law Firm with offices in Virginia, D.C., and Maryland. He specializes in elder law, estate planning, and special needs planning. He has authored numerous books and legal treatises in the field of elder law and teaches classes for attorneys across the country on Medicaid asset protection strategy. He is listed in Super Lawyers and Best Lawyers in America, has earned the prestigious designation of Certified Elder Law Attorney from NALA, and was voted by his peers to be a member of the Council of Advanced Practitioners of the National Academy of Elder Law Attorneys. Please welcome again attorneys Alina Solito and Evan Farr. Welcome back.
Thank you very much.
Thank you for returning to continue this conversation. You know, Evan, we had a lot of good conversation during our first show about the Medicaid process and what you need, the basic rules. But let's talk about some of the common misunderstandings, which we touched on during the course of the show. What are some of those common misunderstandings folks need to make sure they don't come away from this program with about Medicaid?
Well, I'd have to say the biggest misunderstanding is that people think they simply have to spend down their assets and go broke in order to qualify for Medicaid, because that's what they're told by the media, that's what they're told by the nursing homes, that's what they're told if they go to apply for Medicaid on their own, God forbid. That is the biggest misunderstanding. People do not have to go broke. There are about 500 certified elder law attorneys like Elaine and myself in the country that help people every day protect assets in connection with Medicaid. And as a general rule, for a married couple, we can protect 100% of the assets. And for single people, we can protect generally 40 to 70% of the assets. And they don't have to go broke. Another big misunderstanding is the 5-year look-back rule. People who have researched Medicaid on their own, they've read about the 5-year look-back rule, and they think that if they're already in a nursing home because their spouse or their parent or other loved one has just had a stroke, that it's too late. There's nothing you can do because they feel like they had to do planning 5 years ago. That is simply not true either. There is a type of planning that can be done 5 years in advance, which I think we'll touch on a little bit today, but most of the planning we're going to be talking about today is what we call crisis planning, where people do actually come to us at the time of need, and it doesn't matter that they're already in a nursing home and they've done no advanced planning. We can still protect the percentages that I just mentioned.
Well, that's good to know. And I think a lot of folks do have that impression that they are out of luck a lot of times once they hit the nursing home. So, what are some of the common problems that arise in qualifying for Medicaid?
Common problems, well, people trying to do it on their own, or people letting nursing homes apply for them, people not getting proper legal advice from an experienced elder law attorney, which are generally certified elder law attorneys like the two of us.
Do prenuptial agreements come into play at all in the application process? People a lot of times may think that prenuptials will somehow help divide their assets. Does that work for Medicaid?
Prenups do not help in connection with Medicaid. Medicaid basically ignores private agreements among people.
Okay,
So
well,
if
that's
you're a married couple, they essentially ignore prenups. There is a certain use for prenups in certain very specific situations, but
Sure.
as a general rule, they're ignored.
Okay.
A lot of people in second marriages do have prenups, or simply in second marriages, they've kept their assets separate, and so they come to me thinking, well, I'm just here because, or the kids come to us because their mom's in the nursing home, and their mom remarried the second husband 15 years ago, and they've kept their assets separate, and they think all they need to tell me about is mom's assets, and they're extremely shocked to learn that no, Medicaid needs to know your stepfather's assets too. He's got to cooperate in the process, or we can't do any planning, because Medicaid looks at the assets of a married couple regardless of how they're titled. Also, even for couples who are separated, they look at the assets of the married couple.
All good things to people to understand. That's very helpful. Alina, let's talk about, we talked in the first show a little bit about the fact that there's this 60-month look-back rule. Tell me, or transfer look-back rule. Tell me a little bit about, what does that mean? How does that cause disqualification?
What the state does when it looks at your assets is it wants to see if you've given away anything for the purpose of qualifying for Medicaid. So it goes back 5 years, 60 months, and it looks to see for any transfers made, quote, for less than fair market value. So they're looking for gifts, they're looking for large donations, that type of thing that they believe that you did it, you gave away that money, so you would have spent down for the purpose of qualifying for Medicaid. Okay. And what happens is, if they find those, then you have a penalty. So you are technically eligible, but there's a divisor, I think it's about $9,000. For every about $9,000 you give away, you have a 1-month penalty where the state will not cover your nursing home expenses.
Interesting. Okay, that's important to know. Now, are there approved or tested techniques to remedy those mistakes?
You can always give the money back. And
so you can cure it?
You can cure it. And there are strategies designed around gifting and curing. So that's definitely one thing. There may be a hardship involved. If what happened was there was a drug-addicted child, let's say, or a grandchild that absconded with the money, the state has an issue with that. And but because you didn't really give it away, they would give you a hardship exemption for that. Let's say you transferred your home into a revocable trust, which a lot of people do. That's also considered a transfer for less than fair market value and subject to penalty. Sure. So you would have to transfer the house back into the name of the couple or the person. Okay,
okay. Evan, let's talk about planning strategies now. We sort of move into how we, either it's crisis or we're planning in advance, if we hopefully can do that. For a single person, what kind of strategies are out there that they can use if they want to preserve their assets, whether it's for their kids from a first marriage and now they're a widow or a widower, or maybe they have nieces and nephews they want to care for?
Sure. Well, first of all, to address that issue of why would people protect assets, It's not necessarily about preserving assets as an inheritance for children or anyone else. The main reason that most elder law attorneys do asset protection is so that the protected assets can be set aside under the control of a loved one, whether it's a child or spouse, and be used for the benefit of the person who's in the nursing home to enhance their quality of life, to pay for things that Medicaid doesn't cover, like broken or lost hearing aids, eyeglasses, dentures, buying better food, maybe even hiring a private sitter to be in the nursing home to help someone go to the bathroom every 2 hours so they don't sit in dirty diapers for 6 hours a day, which is sadly the fate of many people in nursing homes. So it's important to understand that's part of the ethics of this planning. It's not usually about just protecting an inheritance. Sometimes that is an important goal for our clients, but more often than not in this affluent area, kids are financially fine. They don't need or want the money for their parents. They want best care for their parents, which is what we help them get.
A very, very important point to be made.
As far as the strategies, there are over 24 different Medicaid asset protection strategies that can be used in this crisis mode of planning when someone's already in a nursing home. Some of the basic ones are purchasing a vehicle, purchasing prepaid funeral arrangements, purchasing or making repairs or improvements to your home, since the home is an exempt asset, though the home, we talked about this on the first show, is not a protected asset because in Maryland they put a lien on the home and they get their pint of blood after death by enforcing the lien once the house is sold. But there are, suffice to say, there are dozens of other strategies that can be used, but they're very complex and very fact-specific, case-specific, and they're not do-it-yourself strategies. They're strategies that clients need to come to a certified elder law attorney to get advice and guidance throughout the entire process to make sure that these strategies are implemented properly with the proper timing, the proper steps are taken at the right time. So
the strategies really get integrated because it's not just like you don't just check it off your list because each one of those things is connected in some way, is what I hear you saying. And so I think that's our point to our viewers is to, again, it's not a do-it-yourself process. Let's talk about married people. Okay, there's lots of married folks that got one spouse that's in trouble and has to go to a nursing home.
Right.
What are some of the common sort of strategies, spend down strategies that are used for a married person?
When there is a spouse in the community, that does open up a few more tools. But again, it's very individualized. What you want to do is maximize the comfort of the community spouse. And like we said in a prior show, the community spouse is able to keep a certain amount of assets up to the $126,000 mark. And then it's those excess assets that we need to worry about how to best spend them to protect the community spouse. And we will do things like home improvements, better appliances, funerals, that type of thing. And there's also a very specialized annuity that would be for the purpose of the community spouse. It's a Medicaid compliant. Not everybody offers it. You have to be very careful as to where you get it. In addition to that pre-planning stage or pre-qualification stage, there's a post-eligibility planning that also needs to happen, and that has to do with the estate planning for the community spouse. If the community spouse were to predecease the institutionalized spouse, then suddenly all those assets are available to the institutionalized spouse, and all of a sudden they're off benefits.
Oh, that's true.
So what we do is we create testamentary special needs trusts for the benefit of the institutionalized spouse to make sure that that person's care is always at the maximum that it can be.
Well, I think that's very important to call that to everyone's attention, for married couples, that we do want to make sure that their estate planning documents are in proper order so that they do predecease. We don't want to have them find that all that planning that was done in order to care for the person, but also as a secondary to make sure maybe we can leave a little bit more to our children, is not wasted.
Correct, and understand, as wonderful as Medicaid is, it only covers some your minimum level of care, and if you need something like a customized wheelchair or a better quality denture or hearing aid, Medicaid's not going to necessarily cover all of that, and to have that makes a huge difference in the quality of a person's life.
Well, I think Evan made a good point about when we're talking about the single person, that having an advocate at the nursing home that's there not just to make sure that you have your diaper changed every couple hours, and we see that firsthand, sadly, is also to make sure you can be the squeaky wheel. And a lot of times the elderly person may not be able to be the squeaky wheel, so you have someone who's actually informed enough to be able to advocate for you and make sure that you get that next level of care that you need, and you get it sooner rather than later.
Absolutely.
Because the nursing homes, we've done a couple of different shows about nursing homes. They're challenged.
They are.
They're challenged from a staffing standpoint. So it's not like they don't do a good job. They do a good job with the blocks they have available in order to get it done. But it's a challenge. So I think that's important. That having that extra money to pay for someone like Evan mentioned, again, goes to that care of that particular person. Well, we've talked about all this planning, but we have to eventually apply. And so, Evan, let's talk about the application process. What's involved with making an application in Maryland for Medicaid coverage?
Well, it's a very detailed, very time-consuming, very tedious process. They want 5 years of records for everything, unlike our neighboring states to the south, which only require 3 or 4 months of records. Maryland wants the full 5 years. We, in my office, we have 5 Medicaid paralegals. This is all they do day in and day out, is help our clients by filling out the Medicaid application. I mean, we do the planning, the asset protection, and then we fill out the applications, because this Medicaid itself is the most complex area of law in existence. And to be able to implement these strategies requires the expertise of certified elder law attorneys like Elena and myself. But the actual filing of the application, it's just reams and reams of minutia. And I, as an attorney, don't have the patience for that. That's why I've got a team of paralegals to deal with all that. And it's just details. It's filling out a lengthy application and then supplementing it with 5 years of every financial statement, every bank record, every penny spent for this person over the past 5 years. It's extremely onerous.
And that sort of begs the question, because I know we hear some people are most people do paper applications, but I know some states now allow for online applications. Is Maryland one that allows, do you do an online application in Maryland at all, or is that not available?
We don't do it just because where it's allowed, the only thing that's allowed is the basic application. You still have to submit the reams of verifications separately, so it makes no sense to have application two different parts. It's just a recipe for disaster.
Of course.
Anything electronic, if it can go wrong, it often will go wrong, as we know with Murphy's Law of electronics.
There's gremlins everywhere.
If you're 90% through the online application and the server decides to go down for maintenance, and you've spent 6 hours, that's kind of frustrating.
Of course it is. What are some of the lastly, what are some of the common red flags on a Medicaid application? That again, from a Medicaid planning perspective, someone's reviewing the application, what would be a red flag for them when they look at that application?
You're talking about the eligibility workers who are reviewing?
Yes, sir.
Red flags for them. Certainly the gifts.
Transfers.
Right? Any kind of uncompensated transfers or where they can't tell what this was for. They're going to, at first blush, consider or assume it was a gift until you prove otherwise, that it was not a gift. And there's there's a whole list of exclusions in Maryland, which is very nice. Unlike one of the great things about Maryland, unlike Virginia and DC, is in Maryland we have this long list that Elena helped get through of exclusions, things like paying for your daughter's wedding or your grandchild's wedding or paying for college tuition. Most states, those are considered gifts, and in Maryland, if it's on the list, they just say, oh, that's okay. You don't have to prove otherwise. So
Well, that's good to know.
that's a nice thing.
So, Lena, what are some of the consequences in Maryland if you get a denial in your application? What do you do?
You file an appeal.
File an
Is
appeal?
what you do, yeah. And they do issue denials, not because they're denying the application, but because you don't have all the information in. So they'll issue you a denial along with another request for information. You file your appeal, you talk to the caseworker, you see what's lacking, you see what the concern is, and you try to resolve it as best you can, short of a hearing.
Sure.
Unfortunately, sometimes you have to go to a hearing. The caseworker is not reading things the same way you are. Very frequently, you will go to the eve of the hearing, and at that point, the appeal has gotten kicked upstairs and kicked upstairs and kicked upstairs. So it's resolved. So you don't have to get up at 8 o'clock in the morning to go to Catonsville. So that does happen.
Okay. Well, that's good. How about we see a lot of pro se applicants. So apparently, they file an application, it gets denied, and now they come to see you. Is that something that you can fix?
As best we can, yes. The problem is with pro se applicants and just, in general, if you don't do the planning correctly, you're not eligible. And you may not find out for several months. And in the meantime, your bill to the nursing home is accruing.
Oh, yeah.
And somebody's got to pay for that. If the state isn't going to pay for it because the application wasn't done correctly, then you're on the hook for, it's $12,000 a month.
Ouch. Well, speaking of nursing homes, let's just talk a little bit about this. I know both of you have very strong opinions about this, but a lot of times nursing homes, they want to be helpful, and so they take on the burden of making the application for Medicaid for the prospective resident. What are your thoughts about that? Elena, good or bad?
It's terrible. In a lot of jurisdictions, it's considered the unauthorized practice of law. And the rules are so complex, and you can't find them everywhere. In fact, some of our rules aren't even publicly available. You just happen to have to know about them to know that they exist. So, if it's that difficult for an elder law attorney to figure out exactly what the law is, you can only imagine what a billing person or an administrator in a nursing home would have to go through. This is not their job. That's not what they're paid to do. That's not what they're trained to do. They also don't necessarily, they won't do the training that's necessary to protect the community spouse. So in general, it's just a really bad idea.
Okay. Well, that's, I see we're starting to run out of time here, so I wanted to go to each of you and get some final thoughts. Evan, I'm going to you first. Some final thoughts you want to make and points you want to emphasize about the program tonight.
Well, what we've talked about mostly today is this crisis planning and where people are already in a nursing home and we can protect significant assets. The other type of planning we haven't really talked about is where people do pre-planning 5 years in advance, and that's using one specific Medicaid asset protection strategy, which is a Medicaid asset protection trust, where if people put their assets in 5 years in advance, whether they're a single person or a married couple, they can protect theoretically all their assets after 5 years if they do need nursing home care.
Okay. Alina, how about yourself? Some final comments you want to share?
Well, I think the planning, the pre-planning is critical, and not just in terms of financial. These are very difficult issues for everyone, and to the extent that a family can sit down and have an honest, open discussion about the needs of aging parents or other family members and what the plan is going to be, is a huge, huge relief for everybody involved.
Well, I think you're both right, and I want to thank you both again for taking the time to have this initial conversation. Again, we did focus primarily on crisis planning, and we hope that maybe you guys would agree to come back and be part of some of our case studies as we begin to talk about some of the actual planning we want to do, 5 years or more in advance, so we can make things easier for folks. But thank you for taking the time to do this show, and again, great public service for all the folks in the state of Maryland.
Thank you very much. Thank you for having us.
You're very welcome. Without a doubt, handling the finances for an aging adult can be challenging, and nothing can be more stressful than trying to figure out how to pay for their care needs, especially when your loved one has no long-term care insurance or has financial resources they want to preserve for their spouse or their children. Maryland Adult Long-Term Care Medicaid is a resource that may solve this need, but as we learned during the course of Part 1 and Part 2 in this topic introduction, there are income and asset qualification rules, transfer restrictions to navigate, and many common pitfalls to avoid. But there are also planning strategies for both single and married people seeking adult long-term care Medicaid, and our guests touched on a few of those strategies. Those strategies and others will be examined in more detail in a series of case studies in future shows. But I repeat these words of caution. Whether you are trying to qualify your elderly loved one for Medicaid coverage before a crisis presents itself or during a crisis, please be forewarned that Medicaid planning is not something that lends itself to do-it-yourself efforts. You are strongly encouraged to get advice from a qualified Medicaid attorney early, if possible, in your effort to qualify your loved one for adult Maryland long-term care Medicaid. Early planning, as opposed to crisis planning, typically affords more planning options, especially when you are seeking to preserve assets for your community spouse or other loved ones. This brings us to the conclusion of our show on Maryland Adult Long-Term Care Medicaid. We hope you found it helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.